Budget 2022 is around the corner, and like all taxpayers, non-resident taxpayers do have certain expectations from the budget. And these expectations are surrounding the various developments which have happened over the last couple of years, particularly surrounding the COVID pandemic, so far as individuals are concerned, and of course, the global development around Pillar 1 and Pillar 2 from a corporate tax standpoint. So coming to the individual taxation first, we know that many individuals who were required to come to India for their personal reasons, meeting their families, friends, and who were stranded in India on account of the COVID pandemic, have been requesting the government for various reliefs on account of their being present in India or being forced to be present in India. In FY 1920, the government did provide some relief by excluding the period they were required to be in India in the determination of the residential status. But for FY 2021, no formal relief has been provided. The government indicated that in view of the tax treaties and on account of various reasons, they believe that most of these individuals may not be subject to double taxation. But if they were, the tax authorities had requested that these individuals can complete the details in Form NR and provide to the government, which they will look at on a case-to-case basis. We have not heard any feedback from the government on these Form NRs which we have been submitted, and also in respect of the various petitions which have been filed by the taxpayers. Having said that, there is certainly an expectation that even though the year has ended and the tax returns have been filed, the government will come back and do provide some relief on account of these individuals who will now be subject to tax in India on their income outside India because of COVID pandemic. They were required to be present in India. And these individuals, I think more particularly coming from Gulf and Middle East, who may not qualify as residents, who may not be required to pay tax in those jurisdictions, will be more impacted by virtue of the amendment made in FY 20, whereby some of these individuals will be deemed to be resident in India and therefore will be subject to tax in India on their income overseas, even though otherwise they would not have been subject to tax in India. So all in all, there is an expectation that the government will provide some relief in respect to these individual taxpayers who will become subject to tax in India. Moving on from an individual perspective to corporate, again, like on account of these individuals being present in India, there could be a corporate tax implications from a permanent establishment standpoint. Corporates are also equally looking forward to some relief, whereby the presence of these individuals should not trigger a PE or a corporate tax implications to those companies in India. And while on the context of corporate taxation, one area I think which everybody is keenly looking forward to is the government's response to last year's Supreme Court decision in the case of engineering analysis, where the Supreme Court in its landmark ruling had held that payment on account of software should not be characterized as royalty in respect of the various facts which were there before the court and the various set of circumstances. Obviously, there is a curative and a review petition which the government has filed and which is coming up for hearing on the 27th of January. Pending that, there is an expectation that the government will not make any changes in the coming budget. And perhaps this will be the end of the litigation so far as these aspects are concerned in the context of royalty. One other segment of non-resident taxpayers who are keenly looking forward to some changes in the budget are the foreign portfolio investors. Now, many of these foreign portfolio investors are either structured as trusts or corporates in their overseas jurisdiction on account of various factors which may be peculiar to that jurisdiction. So those coming from UK, Luxembourg, Ireland may be set up as corporates, and many of them coming from US may be set up as trust. But because of the different rates of surcharge applicable to trust and corporates, there could be a wide range of tax impact that these FPIs may have to bear in India. And therefore, there is an expectation that non-corporate FPIs will be provided a level playing field as compared to those FPIs who are structured as corporates. And continuing with FPIs, one other area where they're looking at relief is taxation of income from units of business investment, business trust, that is REITs and InvITs. In view of the amendment which was made last year in the definition of securities, it is quite likely that the income which they now receive on account of investment in business trust may get taxed at 20%, which was earlier taxed at 5%. There is therefore an expectation that the government may clarify those provisions, bring them in line with what was prevailing prior to the amendment made last year, and have this income being subject to tax at 5%, both at the withholding level and at the final tax level, as was prevailing prior to the amendment made last year. Continuing with the corporate taxation, one other area, of course, is all the investments which have been made in India through Mauritius, Cyprus, and Singapore. And we have seen various press reports which indicated that the government is relooking at all the benefits which was granted to these taxpayers and reopening many of these cases. Now, obviously, these treaties have been grandfathered, and all investments made prior to 2017 have been given the benefit of the tax treaty. Having done that, these investors are now confused, or rather looking forward to some clarity as to if the benefits have been grandfathered, why are these assessments being reopened for prior years? And that is not sending correct signals to them as to what is the certainty and clarity that they can look forward to from in investments in India. While there is clarity with respect to investments made after 2017, those investments made prior to 2017 still appear to have some ambiguity. And coupled that, we also see the recent controversy surrounding the reassessment, where all the notices issued after April 2021 have been the subject matter of litigation on the ground that these notices have not been issued following due process of law. And most of the courts have held in favor of the taxpayers. Again, there are eyes on the budget as to whether the budget will make any amendment to ratify or validate all these notices, or will it be decided by the apex court in due course of time. And one other area which I mentioned at the beginning from a corporate tax standpoint, looking at is the development in the global tax field on the OECD Pillar 1 and Pillar 2. The expectation is that there will be some roadmap which will be laid down in the coming budget with respect to India's approach on Pillar 1 and Pillar 2. And when talking of Pillar 1 and Pillar 2, one of course cannot lose sight of the equalization levy. When the levy was introduced in Finance Act 2020, it was introduced at the time of passing of the bill, not as part of the original finance bill. So obviously we don't have a lot of material surrounding the memorandum explaining the provisions or the notes on clauses and so on. And therefore there has been no clarity on the objective and rationale of the levy of equalization levy. And the levy as it stands currently, and given the interplay between equalization levy, the significant economic presence, the royalties, technical fees, and the withholding tax, there is a lot of ambiguity surrounding that. And taxpayers are hoping that there will be some clarity surrounding this in the coming budget 2022. And last but not the least, the topic of budget 22 cannot be, I will say the topic of litigation cannot be, is always be the subject matter of expectation from the government, that there will be an area where litigation will be mitigated in due course. We do have the advanced ruling scheme, which has been recently notified, and the expectation is that the board for advanced ruling will ensure that the rulings are decided between a period of 6 months, and it will not let it accumulate as it happened in the earlier regime of the AR. And hopefully there will be some time limit set for deciding the appeals pending before CITPL and tribunal, so that there is some clarity and certainty with respect to all these litigations happening in India. So that's, I think, all that as of now on the budget 22 expectations from an international tax perspective.